All right. Looks like the clock's just rolled 6 o'clock. That's awesome. All righty. Welcome, everybody. We are excited to do a podcast here on Thanksgiving Eve while everybody's probably doing a million other things like I did all day today. So, welcome to our Triple E podcast. We are going to continue the conversation about your private trust. This is part 2. We'll continue going through the Hague Convention document. Again, is found on our website. Keeping in mind that everything we go over is for education. We just want to make sure we share with you guys. We are not advising you to do anything specific. If you have questions, please reach out and ask. But otherwise, this is for your fun and knowledge and just stacking it up as we go. So Karen, I am going to share my screen.
Perfect.
Okay. For some reason, it does not like to do this. Oh, there it is. Alrighty. You see my screen? I know that you asked me to have it a little bit bigger last time.
Just for our viewers, a little bit of consideration, right? When we're watching
right?
this. Yeah.
All right. Well, let's see. I'm going to go on this side. There we go. Alrighty. If anybody has a hard time reading that, please feel free to go over to our website under downloads, which is empoweredlearningusa.com. You go under downloads. It is the last document in the list. And we are continuing with Article 11 in Chapter 3, category labeled recognition. So last time we went through the first 10 articles, just kind of overviewing everything in here. Again, the topic is your private trust. This is really us going through and summarizing the foundation of using the Hague Convention document that we have here and really understanding the rules of the trust before we start putting one together and asking all these questions on what should be in here and what should not. So we're going to continue this conversation with the next set of articles. We should be able to get through all the articles in our hour tonight. And then that way you guys can move forward with, if you want to start putting some things together, at least you have a foundation of kind of what you need to do. Now, we do have a course coming out in early December that's going to walk you through putting together your basic trust. And that's going to help you guys know what should be in there and help you formulate those a little better with some templates and some suggestions along with a video. So all of our courses have info, video, and documents. And we do try to keep that reasonably priced for everybody. So far, our first 2 courses are $45 because we are not here to gain billions of dollars. We're just here to have value for our time and share this information with everybody so it can be reasonable and you guys can take advantage of as many things as you want to. So on the document, Chapter 3, Recognition, Article 11, a trust created in accordance with the law specified by the preceding chapter shall be recognized as a trust. Such recognition shall imply as a minimum that the trust property constitutes a separate fund, that the trustee may sue and be sued in his capacity as a trustee, and that he may appear or act in this capacity before a notary or any person acting in official capacity. Insofar as the law applicable to the trust requires or provides, such recognition shall imply in particular A, B, C, and D. So Karen, you want to go ahead and go through the letter ones this time?
Sure. A, the personal creditors of the trustee shall have no recourse against the trust assets. Okay, so what does that mean? You got any input on that you want to share?
Let's see. Personal creditors of the trustee shall have no recourse against the trust assets. Again, the trustee is a representative of the trust. They do not own any assets. They are not personally liable for any assets. Their job is to protect the trust at all costs. So when a creditor comes to the trustee and says trust assets, the trustee says that's private.
That's correct. Okay, perfect. And then B, that the trust asset shall not form part of the trustee's estate upon his insolvency or bankruptcy, Meaning that if I am the trustee and I file bankruptcy in my own personal capacity as separate from the trust that I'm protecting, my bankruptcy does not pull into any of the trust assets that I'm supposed to be protecting. They are separate. We cannot commingle the funds or the assets at any time on any level. Okay. C, that the trust assets shall not form part of the matrimonial property of the trustee or his spouse or part of the trustee's estate upon his death. So what that means is that if and when the trustee dies and they leave a spouse behind, neither the trust assets nor the trustee's spouse can be commingled together. They are not commingled together. They are completely separate entities. So can't commingle the funds, right? If I hire a trustee, that trustee is separate from any trust that I have hired that trustee to govern over.
And I'm sure this basically says as well, like, just because you're the trustee, your spouse is not trustee with you, right? Like your obligation as trustee is over if you pass.
Correct. Or are terminated by the beneficiaries or resign.
Correct.
Right?
Yep.
D, that the trust assets may be recovered when the trustee, in breach of trust, has mingled trust assets with his own property or has alienated trust assets. However, the rights and obligations of any third-party holder of the assets shall remain subject to the law determined by the choice of law rules of the forum. Okay, so if I, as a trustee, mess up, screw up, and give trust assets to a Bob Jones, okay, and as trustee, I should never have given those trust assets to Bob Jones, and then I am either fired and or I quit, then other trustees or beneficiaries can hire a trustee to go after the property that was given to Bob Jones. Okay. So that's what we're talking about when we talk about how breach of trust of the trustee does not eliminate the recovery of trust assets if given in the wrong capacity. Okay.
Right. And then the remain subject of the law determined by choice of law rules of the forum. That's when you're putting together your trust, you're letting the document know which rules or laws you're going to follow if something like that were to occur. But this is where you really want to get the understanding of, get out of your mind that this trust is going to go to court. This is where it really, really starts to split hairs, when you've got to think about hiring people. If you're a trustee, if you're dealing with laws, if you're dealing with certain things, you really need to make sure that you have not pulled this private trust into a public arena by your wording inside the trust.
That's correct.
All right, we ready to move on?
Yep. Article 12. Where the trustee desires to register assets, movable or immovable, or documents of title to them, he shall be entitled, insofar as this is not prohibited by or inconsistent with the laws of the state where registration is sought, to do so in his capacity as trustee or in such other way that the existence of the trust is disclosed. Okay, so for a trustee who, let's talk about an automobile. Okay, so if the trust owns the automobile and I want to register the automobile as trustee, where and whom would I register that automobile?
Where are you supposed to?
Correct. Where would registering that automobile be most appropriate?
Well, it's definitely more appropriate in the private capacity. So what you don't want to do is recontract yourself out into existence somewhere that puts a jurisdiction over your private trust that just messes up the whole thing. So I don't know if most people know this, that you can title and register your vehicle inside of your trust privately. You do not have to do statutory documents that we're used to doing. And this is one of the reasons why we're going through this information, because I think a lot of people don't understand when you are doing a private trust, you are in control.
Correct. Very true. So if, let's say the automobile is paid for and I want it in my trust, I could then conceivably create a trust registration certificate, and then that could then become the registration for the automobile, keeping the automobile in the private. Okay. However, if I had an automobile and I don't know that information and I chose to register the trust asset with said state incorporated, have I just relinquished trust asset property to a foreign entity?
Absolutely.
Yep. So it's important that we understand the jurisdiction and what we're doing. Okay. And nothing that we just talked about is illegal or fraudulent or any of that. You're actually keeping your private asset in a private capacity with a private registration certificate with the that is the trust title. Okay.
So this is why we don't see the Rockefellers trust documents.
Right? Or Trump's or anybody else's.
Right, exactly.
Right? Oh, goodness. Okay. And then, so are we on to Article 13 now?
Yes.
Okay, perfect. Article 13. No state shall be bound to recognize a trust, the significant elements of which, except for the choice of the applicable law, the place of administration, and the habitual residence of the trustee, are more closely connected with states which do not have the institution of the trust or the category of trust involved. Goodness, that was a mouthful.
That's a lot to say nothing.
That's all one sentence.
Goodness.
I'm looking for punctuation. There is none. Okay. So do you want to try to tackle that one?
Let's see. So we've got recognize a trust, the significant elements of which, except for the choice of applicable law, again, we just talked about that in the upper piece. The place of administration. So that's your private capacity. You are putting this together. You are your own admin team in this journey.
Mm-hmm.
And the habitual residence of the trustee. Again, I would be careful here with this word residence. If you've gone through our right to travel course, you know that residence is a bad word. So part of that comes with residence, again, hooks you into the corporate construct of contracting. So I think a lot of this is just really saying, okay, so more closely connected with the states which do not have the institution of the trust or the category of trust involved. So no state's bound to recognize a trust except, okay, so we want to watch that, right? So they're not bound in the private administration of the trust that's within your state. But once you jump into applicable law, habitual residence, and you start putting that on the public side, now they're going to recognize it.
Correct. They're going to recognize it and then push to violate it.
You got it.
So it's really important to understand that I may be an agent or attorney in fact, or even the trustee of a trust. Which capacity am I communicating with a government entity in? Am I the agent representing the trust, and am I trying to navigate that? Or is my role as agent really just to protect the trust assets from breach, right? So am I responding more to communication in a threat of breach, or am I actually trying to contract the trust with a government entity, which ideally you would not be doing, but there may be some circumstances where you would want to do that. And if you chose to do that, then what are the laws that are going to bind that, right? Because the government entity certainly is not going to be recognizing your spiritual bylaws within your trust. So what capacity are you actually operating in? And that's what this really speaks to me about.
Yep, and this is why you really need to be mindful of when you choose a trustee, how much knowledge they have. You really should just buy them a no bullying T-shirt when they first climb on board and they've accepted being a trustee, because that's really the nature of the beast. Is they can't be easily swayed, easily bullied, easily intimidated, because they're going to have to stand firm on um, very little information will secure this whole process. There's no
Correct.
reason to divulge, explain, go through. It's literally, I am the trustee of a private trust. Done.
Done. Correct. We don't defend and justify. I mean, we protect, but we don't defend our answers, right?
Yep.
There's no need to. Okay, Article 14. The convention shall not prevent the application of rules of law more favorable to the recognition of trust. Okay, so what that tells me is the rules and laws favorable to the trust shall not prevent the application, right? That's really what it's talking about. The laws and the rules are within the trust body itself. And if the statutory regulation is favorable and unfavorable to the trust, in this scenario, it is favorable only, right? It can't be used against the trust. It is to be favorable to the recognition of it, right? Which is important because you don't want anything to circumvent it passively to then overtake it in the long run. You don't want that.
Absolutely. Absolutely. So we'll move on to Chapter 4, General Clauses, in Article 15. The Convention does not prevent the application of provisions of the law designated by the conflict rules of the Forum, insofar as those provisions cannot be derogated from by voluntary act relating in particular to the following matters: the protection of minors and incapable parties. That's a big one, to just understand the definition of how that impacts in the trust. That's your being of sound mind, and understanding contract. So you, as a minor, and somebody who may be incapacitated that can't perform those duties. The personal and proprietary effects of marriage.
Can I go back to A for a second?
Yeah, go for it.
Understanding also the definition of minor, right?
Yes.
So from the moment that they turn 18, they have 7 years to claim their estate, which then puts that cutoff at 25. And if
Right.
they don't then claim it by the age of 25, then they are an incapable party because they've proven to be incompetent to manage their own affairs. So that protection is really important. So for parents, that protection is huge to teach your offspring what they need to do so that between 18 and 25, you can still guide them so that whenever they're ready, they can actually become the age of majority, and then they can actually create and then establish their own trust and start to run it. So I just wanted to touch on that before we go into B.
No, and that's perfect. That also brings up that there is a whole, I believe it's 16 pages of this just pertaining to children when you're talking about going through all of this stuff, because there's a lot of things to consider. So as we come up, as we get the course put together here for our trust application and putting that all through, we'll have some more information in there, because it is pretty lengthy when you're dealing with children. And I learned the other day that if you want to do this right, we talk about language all the time and what we should and shouldn't be saying. They shouldn't be called children or kids. If you call them offspring, it means something very different in court. So interesting concept as you're putting through your words and you're making sure what you're using is proper inside of here.
Okay.
All right. Next one. Do you want to go into B?
Yeah, go ahead. Do you want to read it?
Yep. Personal and proprietary effects of marriage.
Okay, so if you're married, you have a trust and he has a trust. I'm saying he because there are other parties, right? So if we have a trust and we're married, then our trusts are separate. we can then create a joint trust, and we can put assets from our individual into our joint. But typically a trust just has one party or the other, or you have a trust to be a trust inside of another trust. So there's different ways to lay those out, depending on what it is, right?
And it definitely keeps it a lot cleaner when you have things separate like that, because you don't understand the nightmare until after you've already done it that way, when somebody has to deal with it after the fact. Being a kid who, I've gone through 3 different trusts in my family, between grandparents and parents, and, each time they all thought they had the majority of it all put together, and there were still things that, we had to make sure were handled properly. Now, luckily, I had a small family, there really wasn't a whole lot of people to be involved and get opinions on, but if you got more than 2 people in your family and you're dealing with things like, we had everything go out of order in my family. It was my dad first, then my grandmother, then my grandfather. My grandfather would have never guessed that he would have been the last one standing. So when he wrote it, it was written the other way, but he made an addendum to the trust as soon as my father passed away, which saved a lot of headache for my brother and I, making sure that that was addressed ahead of time. So those key pieces and the changes especially are, super, super important that you stay up on your trust and keeping it updated.
They are. Also, the words and or are very important, as well as the word both. Because what I've seen in just trust that my family has had is they will write party one and party two. Well, then if one party dies, passes on, then what happens to the and? Okay. Then you've got or this party or this party, which is great. But then you may have party A and both party B. So it really depends on how the trust is written as to who is granting authority. Can it be either or does it have to be both? Or is it automatically this one and then that one? So it really matters how you actually write that when it comes to being married or having a life partner, spouse, whatever that looks like.
I think I said this on the last podcast, is this is a great way for you to, especially females, if you're putting something together, this is a great way to be the voice of mom after you're gone, because you put everything in place and they have to listen to you.
That's right. That's right.
All righty, we're on C. Go ahead.
Succession rights, testate and intestate, especially the indefensible or indefeasible shares of spouses and relatives. Okay, so succession rights. If I am, let's say I'm a trustee of someone else's trust, then who is my successor, right? So some trusts have that established, okay? So when I'm gone, it then becomes my husband as the trustee, right? Of someone else's, Mary Jo's trust, right? She may choose that. Now, if I am the beneficiary and this is my trust, then once I'm gone, who is then going to be my successor? And it's really important to think about that kind of stuff, because as we look about and think about, well, okay, this is my living trust and I want this to be living on in perpetuity when I'm gone, but what does that really look like for generations to come? So looking at that succession rights and who is the beneficiary and who's actually going to run it, right, is really important. And I can't tell you how many friends and family members I have, and they say, well, okay, I might have one person that could be the trustee, but really I don't have anyone that could be the trustee, right? I don't know anybody long enough. I don't feel like I trust anyone enough to trust them with my assets. And this really was kind of a barrier for me. I thought at first when I started this journey that if I had a trust, that meant the trustee had control of everything that I owned, and that freaked me out a bit. Mm-hmm. But what I came to realize was the trustee can only do what's in the trust. They can't do anything outside of that. And if they do, then they are personally liable for the harm and negligence that they've done. Okay, so this education part around this piece was huge for me, and realizing that I have a lot more authority than I thought I had, and a lot more security than I thought I had. But this was a barrier for me to get through in this learning process. It really
Yeah,
was.
great point. Yeah, because trustees, you really shouldn't be, related to anybody, not by marriage, not by anything. And then you sit there and you go, okay, well, that eliminates 90% of the people I was thinking of helping me utilize these kind of things. So, yeah, it is difficult, but I that's a great point because it's not about letting somebody into all your personal stuff. It's
Mhm.
really saying, here's the rules. I need you to follow these rules for me and protect what I have in here.
Mhm.
That's just it, right? So it isn't relinquishing any kind of authority. And again, because we have the authority to write it, we just there's just so much to think about. So that's why we're really utilizing the Hague Convention document to give us that foundational piece so we're not missing things and we're not forgetting about the little stuff because there is so much to it and it can be really overwhelming.
Absolutely. D, the transfer of title to property and security interests in property. That's really interesting, right? Because the transfer of title, first of all, okay, I've done some things with vehicles that some people don't want to do, that kind of stuff. And when it comes to that, my automobiles are privately owned. Okay. They're just paid off. I don't have a mortgage, I don't have a loan on them. Okay. So, in that, we talked a little bit about a trust creating a title for the property. If a trust can create the registration, the trust can also create the title, which is the certificate of ownership. So, okay, that's great. And we can do that, right? And then who then has the security interest in the property, right? So that's where we separate the title from the equity. Okay. The title sits in the trust because the trust owns it, but the equity is actually utilized by the beneficiary, right? So we've separated the two, and they're not commingled, and no government entity owns it. So this is what that refers to. This is what I think of when I read that. It
Yep.
can happen with heavy machinery, it can happen with manufacturing stuff, it can happen with property and homes. So there's really no limit to what you can do here. However, I have not seen this work for any asset that has a loan or a mortgage or anything like that on it. It really needs to be owned outright in order for you to be able to put it in your trust with your own title documents on it.
Well,
So,
I think that that brings up a really good point too in reference to the assets and what's the famous phrase that's out there is control everything, own nothing.
right.
Because, we are so bent on but it's mine.
Mhm.
And that's not how you protect things because if it's yours and somebody's going to come after you. If you want it protected and you put it in the trust and the trust owns it, you know, you get to walk away hands up and go, nope, it's a trust asset. It belongs to my trust. Oh, you want to see what's in that trust? Well, talk to my trustee, and the trustee will be like, nope, it's private.
Correct.
So that's where people need to really start thinking differently when, you know, it's not about he who dies with the most toys wins. It is literally you do not want to have it listed in your name because then you are personally attacked, you're liable, and then you negate all the protections that come from having a trust with a trustee. So that's why having the trust is so important. And it's amazing to me how few people actually put a trust together because they're always waiting for someone else to do it or pay for it, and they're not cheap. I mean, to have somebody do a legal trust is not cheap, and you don't want it in that jurisdiction anyway. So it behooves everybody to take the time to learn the basics of putting your own trust together so that you can I mean, geez, even if you get just the basic stuff, your big stuff, just start small, with the things that you have, and you can always update things as you go through, but it's super, super important, um, to really cover those assets, and you don't need to have millions of dollars in assets. If you don't if you don't want your stuff going into probate and you don't want your stuff being handled by the state, something happens to you tomorrow and you don't have something in place, you've lost all control of it. So keep it in your name. You won't control anything. Put it into a trust and it's protected, and the trustee will control how things go in and out of that trust. So just kind of wanted to touch on that just because it just seems to me like trusts are not a popular thing and everyone should have them.
Correct. The security interest in property, I just want to touch on that before we take off on E. The security interest in the property, I really see multifaceted. I don't see this just being, well, my asset is in a trust, so everything's protected. There's things like POAs, power of attorneys. There's things like the Uniform Commercial Code and the UCC filings. So there's other things that we can do to actually protect those assets. But the simplest, most basic form to protect it is to put it into a trust and then learn those other avenues of enforcement as your education expands. And we'll have trainings on that stuff. But right now we're just talking about the trust and where's my security in that asset being privately protected. So I just want to touch on that.
Perfect.
Terry, you want to do E?
Alrighty, so we've got the protection of creditors in matters of insolvency. All right, so we're talking about the insolvency of the trust, correct?
Correct.
Alrighty. So, yeah, I'm gonna let you tackle this one because, yeah, when you talk about this trust going bye-bye, what happens from the creditors aspect when the trust goes?
Well, when the trust goes, everything goes, right? So when we're talking about when if I'm the creditor, right? Because I'm the one putting the assets into the trust, when I'm gone, then those assets, whatever they are, have to be disseminated. How do those assets get disseminated? That depends on what the laws in the trust say. Is everything sold and then dispersed to the beneficiaries? Or is it really then, when we get down to, is it a meeting at the end of the trust and then we roll it over for another 25 years? What is the law in regards to that? Now, when we're talking about the protection of the creditors, okay, so let's say that I'm the beneficiary of a trust and I'm starting my trust and I'm moving assets into my trust. And then let's say somebody starts coming after me because they think that I'm the debtor and I owe them. Then my job is to go to my trustee and say, hey, trustee, I need some help because I'm the beneficiary. Can you help me with this other entity that's coming after me? So there's a lot of protections that the trust has, as well as the beneficiary, when it's written properly, right? And when it hasn't been breached and you've got a bulldog for a trustee or somebody that knows enough that all they can say is, nope, I'm the gatekeeper, right? I'm not disclosing anything. And then that's it, right? Like that's supposed to be your trust protector, is supposed to be your trustee.
Makes sense.
Got anything you want to add on that?
Nope. I think you covered that one. All right, F, the protection in other respects of third parties acting in good faith.
The protection in other respects of third parties acting in good faith. Okay, so my job as trustee is to do no harm. That's it. My job as trustee is to see that whatever the beneficiary needs, the beneficiary gets with reason, right? So when I say within reason, I really mean the prudent person test, right? So we hear the term, but what does it really mean? So I asked the question, would a prudent person buy a ink pen for $1? Would they? Probably. Would a prudent person buy an ink pen for $10? Well, maybe. That's kind of expensive, so it better be a really nice one and maybe have special features that I need for $10. But would a prudent person spend $10,000 for an ink pen?
Probably not.
Well, our gut reaction, right, from kind of a gut punch is no way. You'd be crazy to spend $10,000 for an ink pen. However, are you an ink pen investor? And is that $10,000 in 6 months going to make you $15,000? Then that $10,000 pen might really be a good investment if it's going to grow the asset to the trust. So we really need to ask the prudent person test. Do I really need that? Does the beneficiary really need that? Does the beneficiary need an automobile? Probably, but they don't need 3 in the same year, right? So what are we really looking at? If you're going from a dilapidated single family, 1 room, 1 bathroom, 600 square foot house to a $5 million mansion, a prudent trustee would be like, yeah, how about we get you to a 1,200 square foot house? We
Right.
let you live there for 10 years, right? Because you're going to have a huge learning curve when it comes to house ownership, right? So the prudent person test really works in any capacity. So when we're talking about the protection in respects to acting in good faith, as a trustee, it's our duty to protect the beneficiary, even though it might not look like it, right? And it's our duty to actually grow the assets of the trust. That's our duty, to grow it and to protect it all at the same time. It's our duty. Okay. And then third parties. Well, that's the bulldog. That's the gatekeeper, right?
Yep. So this one's interesting when you talk about, again, courts and public versus private. So if recognition of a trust is prevented by application of the preceding paragraph, the court shall try to give effect to the objects of the trust by other means. I'm going to assume that's pretty much irrelevant in a private trust.
Correct. That would apply more to a statutory one.
Right. All right. So Article 16, the convention does not prevent the application of those provisions of the law of the forum which must be applied even to international situations, irrespective of rules of conflict of laws. If another state has a sufficiently close connection with a case, then, in exceptional circumstances, effect may also be given to rules of that state which have the same character as mentioned in the preceding paragraph. Any contracting state may, by way of reservation, declare that it will not apply to the second paragraph of this article. Again, a lot of words to say. Go for it.
Okay, so I was thinking of the rules of conflict of laws. Okay, so we read earlier that it's got to be, and I'm paraphrasing, it's got to be favorable to the trust, right? So we just read that a little bit ago. So if there's a conflict in the laws, if the trust actually puts in the trust indenture, the trust document itself, if there is a conflict of laws, the trust supersedes everything, right? Then what we've already stated, if there is a conflict, who is going to win, right? We've already outlined that in the trust document itself. And that is huge because what I'm seeing, which is a little bit concerning to me, and I have not done this, but I'm seeing this in a lot of arenas, is people are using case law references when they're arguing a trust matter. Well, that's interesting because what you're doing is you're saying an outside entity's opinion has weight when it comes to a private trust matter, and that's a conflict of jurisdictions and an oxymoron, because if your trust is private, you've got no outside opinion that's even going to matter. And so that's where this really comes into play. Who are you stating has the superior claim when it comes to the law? That should always be your trust. Always.
So then I have a question here as we move to Article 17, because it ties right into that. In the convention, the word law means the rules of law in force in a state other than its rules of conflict of laws. So in a private trust, Are you able to replace your state law with God's laws and common law?
You can, however, common law is really common courtesy, right? And so a lot of trusts then have what's included with them as an addendum. Some people put it inside their body, those spiritual bylaws. This is what you're bound to. So it really depends on how you want to write it. But yes, a lot of people do that.
Perfect.
Right. And common law can change, right? The common courtesy of the 1920s really is sparse when you're talking about the common courtesy of 2024.
Right.
Right. So common isn't so common. So you really need to define what that actually is. And when you're talking spiritual bylaws, I've seen people put in references to spiritual literature. I've seen people put in the 10 Commandments. I've seen people write their own spiritual, just take out various scripture pieces and put them together. So if you're writing the law, it really is left open to the creator as to what is your trust law. What is it? You create it. What is it? What do you want it to be?
Yep. Which might make people cringe, but get a little bit of education behind you, and it's actually a lot easier than you think it is. It's
Correct.
easier than trying to decipher all this other law, I'll tell you that.
Oh my gosh. All the rules and statutes? No, thank you. I don't want to memorize those.
You got it.
Mm-mm.
Alrighty, Article 18. The provisions of the convention may be disregarded when their application would be manifestly incompatible with public policy.
So your trust law is incompatible with public policy. Why would you be using Supreme Court opinions on a private matter?
And this goes back to private law and no policy supersedes law.
That's correct.
Alrighty, Article 19. I like these little short ones. Article 19. Nothing in the convention shall prejudice the powers of states in fiscal matters.
Oh, imagine that. Imagine that. I think that one pretty much sums it up.
Yeah. Right.
No explanation needed. Be careful how you autograph your documents.
That is correct.
Right?
100%. Alrighty. Article 20. Any contracting state may, at any time, declare that the provisions of the convention will be extended to trusts declared by judicial decisions. This declaration shall be notified to the Ministry of Foreign Affairs of the Kingdom of the Netherlands and will come into effect on the day when this notification is received. Article 31 is applicable to the withdrawal of this declaration in the same way as it applies to a denunciation of the convention.
Okay, so when does your trust become effective? When and where, right? That's really what that's speaking to, right?
Right. All right, Article 21, any contracting state may reserve the right to apply the provisions of Chapter 3 only to trusts the validity of which is governed by the law of a contracting state.
Okay.
So again, private versus public, is it necessary? You're talking law and courts and governance. So keep it in your own backyard. Article 22, the convention applies to trusts regardless of the date on which they were created. However, a contracting state may reserve the right not to apply the convention to trusts created before the date on which, in relation to that state, the convention enters into force. Now, would this be part of where they're talking about, like you and I have talked about in the past, where somebody creates a trust, they list all of their assets, do everything, but something happens to an asset or something happens to something that's outside of the trust. And what you cannot do is immediately go in and decide that you're going to cover that under the trust because something happened. This is why it's so important to get things done ahead of time.
No. Don't do that, right? No. Right? Don't do that. Don't do that. Okay, so let's go to an automobile example. Okay, I'm working on my trust. I list all my assets. I got my trust running. My trust is operating, but I forgot to put my main automobile under it. Now I get in an auto accident, but my trust is not covered under my Schedule A for my trust assets. And my car is actually registered with the state. It's not in the trust, right? And now because I've got a mess, or now because I got a DUI, or now because I've got who knows what, then now what happens is I can't then hide that under my trust and say I have no liability. No, you can't do that. You cannot run from a mess that you've created by throwing something into a trust. And here's something I was asked today, and it made me cringe a little bit. And somebody asked me, could they backdate the document? Okay, no. The answer is no. Do not backdate anything. And here's why. If you do one thing that is questionable in regards to any of this, you have set the precedence for everything to be questioned as far as ethics. So you want to be really careful that what you're doing is honorable and it's trackable and it's dateable, and that you can say with clean hands, I did not know I was making that mistake. And then it can be a mistake that can be corrected. But if you backdate something that was premeditated and that collusion and a whole bunch of other stuff that you don't want to get into. So
Yeah. No, you're absolutely correct. That's the whole point of doing this stuff the right way is there should be no need to do any of that, because when you have the understanding, you correct it the right way, you do what you need to do, and you're in good shape.
correct.
All right.
Okay.
So I lied. We're not going to get through this whole thing tonight, but we do have a great stopping point, so we're going to finish these last couple articles before we get into some questions.
Okay, good.
So we just finished 22, Article 23. For the purpose of identifying the law applicable under the convention where a state comprises several territorial units, each of which has its own rules of law in respect of trust. Any reference to the law of that state is to be construed as referring to the law in force in the territorial unit in question.
Correct. So where's your territory? Do you know what your territory is? If you're wanting a private trust in a territory, which is the republic, then you need to know where it is and what it is, and have you referenced that for the purposes of identifying this. Does your state have, I'm talking about America, does your state have its own organic constitution? Do you know where it is? Have you read it? It's really not advisable to be creating a private trust. State that you want the original organic constitution of your state to be the supporting documents for your trust, and then you've never read it. Be not advisable to have that be the case. You've just contracted or agreed to work in unison with something and to have never read it. So,
especially when there's 5,000 amendments to a constitution, you better not just be picking and choosing the most recent one and what all is in there. So there's some phenomenal foundational documents that really have paved the way for how simple this needs to be, and it's just gotten convoluted over the years with way too many statutes, laws, addendums, amendments, whatever you've got, even unlawful amendments. So it's really the foundational pieces of empowered learning is getting that basic education of understand, exactly, Karen, what you just said is so important. Understand your local references and what is somebody going to look to hold you to, and be ahead of the game and understand what it is that exists, because it's super helpful. It's just really, really there to help you. All righty.
24.
Article 24, a state within which different territorial units have their own rules of law in respect of trusts is not bound to apply the convention to conflicts solely between the laws of such units.
Okay. That really aligns with what we were just talking about.
Yep, absolutely. And then Article 25, the convention shall not affect any other international instrument containing provisions on matters governed by this convention to which a contracting state is or becomes a party. Contracting state. Love these words.
Yeah. So who's the other party to my trust? Who's the other contracting state as a party to my trust?
In which capacity are you talking about as you?
Right? Good question, right?
Mhm.
Because who is you? So the convention shall not affect any other international instrument containing provisions on matters governed by this convention. Okay. To which a contracting state is or becomes a party. So if we're talking a trust and I'm contracting to another state or trust, who's the other party? So let's say I have a trust and let's say you have a trust. And let's say we want a contract. Who are the parties?
It depends on who the grantor is, who the trustee is, who the beneficiary is.
Okay, but is it really grantor, trustee, and beneficiary? Or is it trustee agent to trustee agent? Who's the contracting party, right?
True.
Because the trust is only going to be the governing law, right? So if I'm contracting with you to, let's say, I agree to pay you to construct a garden shed. Okay, my trust is only going to govern how I pay you, and or my trust is going to govern the stepping stones before I pay you, right? A has to happen before B happens, before C happens, and then D I can pay you, right? If you're building the garden shed, your contract, your trust documents have to stipulate how are you going to build it. Are you going to use wood foundation? Or are you going to use concrete? Are you going to use wood siding? Are you going to put a roof on it, right? And so your trust document and my trust document, we have to agree. So when we talk about our trusts have to agree, right? Are you and I in the same territory? Are you and I in the speaking the same language? And if we are, then my autograph as agent and your autograph as agent has now cemented the contract that we're talking about. A contract is a trust. A contract is a convention agreement, right? So when we read Article 25, we have to look at who becomes a party. Well, who becomes a party is the signers, right? That's who becomes a party to the convention, to the contract.
So you could also reread that last statement and say, let's see, to which a principal is or let's see, hang on. So when we're talking state and we're talking trust and we're talking entity, that's principal, right? And when you're talking about party, you're talking about agent. So
Correct.
what Karen's really getting at here is an entity can't sign for something. There has to be an agent that signs for that. And that agent's signature is what activates that contract and that agreement between what we're trying to do. So we will be doing a podcast that goes a little bit more in depth on principal and agent because that is so important to understand the capacity of an entity versus the capacity of the person and who's holding who accountable.
Correct. Great.
Perfect. All right. So we only have about 7 minutes left. That kind of went by really quick. Couple questions. So let's check on a couple of these here. Okay. So when creating my trust, should I use the state I live in as a guideline, say through like Rocket Lawyer?
Okay, so as the state you live in, okay, I have created several trusts, okay, and there's some really great attributes that I really like with Rocket Lawyer. I really like some of the stuff that they do, and a lot of the stuff they put out is fabulous and great. However, I don't trust that what they're putting out is in the right jurisdiction that I want my stuff to be in. Okay, so Absolutely. You could go on there and you could sign into Rocket Lawyer and you could say, hey, create me a trust. Absolutely. You totally could. Chances are that's going to be statutory when you do that. Chances are. Okay. So if you don't understand jurisdiction, then I would pause on that. Okay. Be a great place to start reading and start learning. Absolutely. What I did was I found a resource that I really liked, and I really liked the resource, but the way they had a trust written, I didn't particularly like, but I really liked the educational material. I found another book that I really liked how they had a sample written out for a trust. And what I did is so that I could learn, I retyped that entire thing word by word so that I could actually learn the language before I ever set up my very first trust. And I would encourage people to do that. Just really take the time to learn it. It is not hard, but it does take time. And I would encourage everybody to invest the time in their education. Everybody.
Absolutely. And I think, that brings up a great point too, that again, you could have a lawyer set up your trust for you, right? And you never read a word in it and you never know what's going on. And then what happens? You have the trust and then you pass away and somebody else is left to interpret all of that. So if
Correct.
you didn't even understand the trust as it was written, you weren't around to educate what anybody did, right? My grandfather, even though he did have, um, I think he did a little bit of both. He did a little bit of his own because he didn't know anything about public versus private when he did his. It was definitely in the public arena, but he handled it a little more like a private trust where he sat us down and he walked us through some stuff, and it wasn't just like, hey, it's in the file drawer over there. It was like, hey, I want you to know my wishes, right? I want you to know, like, because what's number one thing that's usually not in a trust is how someone wants to be buried. Number one question that happens the second you go is the first thing everybody goes, well, what do we do now? So if you haven't communicated that verbally, you definitely want to get those things in writing. And it is good to sit down and educate your family and those involved, and not just the trustee. And you don't have to tell them everything, but giving everybody an overview. Not only that, but you're also leaving a legacy for others to start learning. If they see that you can do it, you're going to encourage your family members to also do the same thing. And that way they can understand it through you and it can start to perpetuate down. So I know that with both my mom and my grandfather, they both did trusts that were set up by an attorney, but they actually put their own 2 cents into it, and they really communicated with us what was in there, what was the key things, what was most important, and who do we go to if we had questions. So
Nice.
that was great
Nice.
pieces of information. I'll throw in one more little quick question here. When getting your trust set up, what's the best place to start?
When getting it set up. Oh my gosh. So are we talking about resources, or are we talking literature? Are we talking people?
If
What
I decided today, yep, no, great question. If I decided today, you know what, I'm going to sit down and tackle this thing. I'm going to just really start to tackle, I want a private trust. What's step one?
what is it? What assets do you have, and what do you want to do with them? Because you've got to start having a conversation, right? Okay, so everything I own, and these are just scenarios I'm throwing out there, right? Everything I own has a mortgage or a loan on it. Well, okay, so what do I have that I actually own? Well, I own $150 in jewelry and $50 worth of clothes. That's all I own. Okay, well, a trust might not be the right thing for you to do. Okay, might not be. Now, do you own your own car? Great. Then the next thing to do is, well, okay, great. So you have an asset that you want to put in a trust. Do you know what the functions of a trust are? Is that even a place to start? Right? Taking a look at that Hague Convention that we just read, and then filling in some of the blanks. Do I even know what they are? right? Maybe going on to Rocket Lawyer and saying, okay, create me a statutory one, and then reading it and going, okay, that doesn't sound right, circle it. That doesn't sound right, circle it, right? Or these are things that I would change, right? So the other thing too is start having conversations with people and start asking them, do you have a trust? I'm thinking about setting one up. Really? Me too. Oh no, I don't own enough for that. Oh, okay. So maybe just manifest even an extension of enlarging your territory. And I don't mean your land, but I just mean who your friends are, so that you can start having some of these conversations, because it's going to be much easier for you to talk about trust with people that have one versus people that don't.
Yep, we call that circles of influence, right? They just got to
Correct.
expand your circle of influence. So, great place to leave off. So next week we will do the third and final of the private trust, and we'll get through the last of the Hague Convention document. And then I look forward to moving to that principal and agent conversation after, because that's going to be super important as we move through. Again, please help us out, subscribe, website. I appreciate you guys taking the time to this information. Feel free to shoot any questions to our info@empoweredlearningusa.com. We would just love to be able to interact with you guys as much as possible and see what we can do to help. Next podcast, December 4th, same 6 o'clock Pacific time. We'll go for an hour. Again, we like to respect everybody's time. So we appreciate it. Thank you. Thank you, Karen, for